Welcome to Module 3. This is the last module in the course, and in it we're going to focus on tort law. This lesson provides an introduction to the role and the purpose of tort law as it relates to the business environment. To this end, it defines tort law, distinguishes it from criminal law, and discusses the nature of liability in tort, and provides an introduction to what kind of damages are recoverable in a tort action. Consistent with the theme of the course, this lesson also emphasizes the importance of managing tort risk. I'm hoping you find tort interesting. We're going to be talking about things that you've heard of before, such as negligence and assault and battery and slip falls. And so most students find it to be pretty interesting. The cases, each tell their own story, and you can see where the law came from. So as always, I've outlined what I would like you to know. So you should understand the broad scope of tort law, understand the differences between a civil action and a criminal action, the different classifications of torts, the purpose of tort remedies, and the types of damages in tort. There are also terms listed at the end of the chapter that you should know. And for this chapter, I'm asking you to be familiar with one case, Filoka versus Pinkertons of Canada Limited. So we're talking about tort law. We're not talking about a delicious dessert. We're using tort to describe any harm or injury caused by another person other than those that come up through breach of contract and for which the law provides a remedy. A tort is basically a wrong to another person. In particular, it's the interference with another's person, property, or reputation. Can you think of some examples? You're probably already familiar with some, but may not have heard them labeled as tort law before. So think negligence, trespass, defamation. Those are all examples. So let me just kind of look at a few of those. So trespass to land. So that's the wrongful interference with someone's possession of land. Deceit or fraud. That's a false representation intentionally or recklessly made by one person to another that causes damage. Negligence, we'll spend a great deal of time looking at negligence. It's unreasonable conduct, including a careless act or omission that causes harm to another. Fault is a really important consideration in tort law. It means that the law of torts will not automatically provide a remedy when someone's been physically or economically injured. The court will consider whether the actions of one person cause the injury of the other. So tort law seeks to impose liability based on this notion of fault. Let me give you some examples. Example 1, I am driving for Uber. I work 14 hours straight. I fall asleep at the wheel and crash, injuring my customer. Have I committed a tort? Example 2, I am driving for Uber. I have a seizure, crashing and injuring my passenger. I have no history of seizures and no risk factors. Have I committed a tort? Generally speaking, the first example is more likely to be successful in tort, as the poor decisions by the Uber driver cause the harm to the other. So by driving for 14 hours straight and not getting the proper rest, I am putting my customer in jeopardy and I have caused the harm. In the second example, there would be nothing that I, as the Uber driver, did to cause the injury. Nor was there anything I could do to prevent it. So I didn't have a history of seizures, I wasn't engaged in risky behavior, I did nothing to cause the injury. So the first case is more likely to be successful in tort. I should note that the law does vary from province to province, particularly in the example of vehicle accidents. So before we delve a little deeper into tort law, let's look at a bit of terminology. So the first is a tortfeasor. A tortfeasor is someone who commits a tort. The person to whom the tort was committed can be referred to as the victim, or in court they would be known as the plaintiff. Sometimes two or more people are held jointly responsible by a court for the plaintiff's loss or injuries. And in that case, we call them joint tortfeasors. So tortfeasor is the person who commits a tort, And if more than one person commits the tort, we can call them joint tortfeasors. So a primary objective of the law of tort is to provide compensation to persons who are injured as a result of the actions of others. So compensation to people who are injured. It's important to note, however, that not every injury will result in a remedy. So in other words, tort law does not always provide a remedy. And we're going to look now at a case that illustrates this well. So the case is Foloka versus Pinkertons of Canada. And I'll give you a little bit of the background to the story. So there'd been a bitter strike at the Royal Oaks gold mine during 1992. A tentative agreement was reached between Royal Oaks and the union, but was rejected by the union membership. Royal Oaks continued to operate the mine with replacement workers. Unfortunately, the strike became violent, and security guards from Pinkertons were hired by the mine. The violence continued to escalate, resulting in riots, damage to property, and injury to the security guards. A number of the miners got fired, including union member Roger Warren. Explosives were then stolen from the mine by 3 of the miners, and during the summer, explosions were set which damaged company property and the mine's ventilation shaft. In September, Warren planted an explosive device inside the mine. The device was tripped when a manned car went over it, and 9 miners tragically were killed. The government ordered that the mine be closed, and Warren was subsequently convicted of second-degree murder. The survivors of the 9 victims brought an action in negligence against Pinkertons, arguing that it failed to take reasonable precautions to prevent the murders of the miners. The Northwest Territories government, the union, and Royal Oaks mine were also sued, but we're going to focus on the Pinkertons case here to illustrate this point. So the legal question is, did Pinkertons commit the tort of negligence? The court said no. The court ruled that Pinkerton's legal obligation had not been to ensure that the mine entrances were properly guarded to stop intrusions. Instead, Pinkerton's obligation was to use reasonable care to prevent such intrusions. The legal rule resulting from this case is that the court does not always provide a remedy. What that means is even when a person becomes injured, a remedy in law is not always available to them. Context is important, as are professional responsibilities. The court doesn't demand perfect performance, but rather reasonable care. And so Pinkertons, as the security company, had demonstrated that they performed within their professional responsibilities. They performed reasonably. The law of negligence, which we'll discuss in future lessons, requires that the defendant takes reasonable care in conducting its business, but that it not assume the position of guarantor. They couldn't guarantee that nobody was going to get onto the mine property. Accidents can happen, bad things can occur without it being the fault of any of the named defendants. Tort law demands accountability, but only in the context of culpability. And culpability is otherwise known as fault. This was an important case in that it illustrates that harm can happen and compensation is not always available, and the court will look to the reasonableness of the behavior. They will look at professional responsibilities and won't hold a profession to an unreasonable standard. There are 2 main types of torts: torts that are committed intentionally and torts that are committed through negligence. So an intentional tort is just as it sounds. It's a harmful act that's committed on purpose. Examples are assault and battery. You should understand that assault and battery have slightly different meanings in tort law than they do in criminal law. So in tort law, assault is the threat of imminent physical harm. So it's not the actual harm, it's the threat of physical harm. Whereas battery is the intentional infliction of harmful or offensive physical contact. So in tort law, we talk about assault and battery. Very often in criminal law, we refer to assault as the actual physical harm. Remember, in tort, it's the threat of imminent physical harm, whereas battery is the infliction of the physical harm. Another intentional tort that you'll come across would be the tort of false imprisonment. This could be the unlawful detention or physical restraint or coercion by psychological means. An example of this would be a security guard who intentionally prevents a customer from leaving the store because they mistakenly believe that they have shoplifted. So the second type is negligence. So this is unreasonable conduct, including a careless act or omission that causes harm to another. So it's unreasonable. Somebody has to determine whether the conduct was reasonable. And conduct can include a careless act, or it can include a failure to do something. Now, there's legislation that does come into play when we start to talk about negligence. One example would be workers' compensation legislation that provides no-fault compensation for injuries instead of a right to sue in tort. This is common in workplaces, and so if an employee is injured on the job, workers' compensation legislation comes in and provides compensation for the injury, and it means that the person who is injured does not have a right to sue in tort. Sometimes an injury can bring two types of action. So, for example, let's say that Gretchen decides to drive home after consuming a great deal of alcohol, gets into an accident, and significantly injures another driver. There could be, and likely would be, two legal consequences here, one of them under tort law and one under criminal law. So criminal law, which we don't cover in this course, punishes people who violate the criminal code. The action that's brought is called a prosecution. It's usually brought by the Crown prosecutors. It includes the complainant and the accused or defendant. Under criminal law, the Crown must prove its case beyond a reasonable doubt. In tort law, the victim can sue for compensation for the harm suffered. It's called a civil action, and the injured party, not the Crown, actually brings the action. The person who brings the action is called the plaintiff, and the person to whom the action is brought against is the defendant. Under tort law, the injured passenger must prove their case on the balance of probabilities, and we looked at that term in contract law. So it has to be, if you remember, greater than 50% chance that the accident happened the way the plaintiff says it did. The purpose of criminal law is to sanction behavior and secure punishment, but the purpose of tort law is to compensate the victim for harm suffered due to the culpability or fault of another person. Both of these actions could arise as a result of Gretchen's choice to get behind the wheel of the car after having consumed alcohol. So as we just saw, the standard of proof is different. It's actually higher, much higher in criminal law than it is in civil law. Why do you think this is? Why would the standard of proof, also called the burden of proof, higher in criminal law than it is in civil law? If you think about it, someone who's convicted of a criminal offense stands to lose their freedom via imprisonment. Because of this, the Canadian legal system places a higher standard of proof than in a civil suit. This also means that someone guilty of a crime may nonetheless be set free because the Crown could not prove its case beyond a reasonable doubt. However, this is the bargain the Canadian justice system has made to try to prevent wrongful convictions. A related reason for a higher standard in a criminal matter is the stigma that comes with a criminal conviction. Unfortunately, even with the higher standard, the innocent are sometimes convicted by the Canadian criminal justice system. There are unfortunately many cases where this happens. One of them would be the case of Tammy Marquardt. She was a young single mother from Ontario who was imprisoned for 13 years for the murder of her 2.5-year-old son on the basis of an erroneous forensic pathology expert testimony that the cause of her son's death was asphyxia. This was later found to be not the case, and she spent 13 years in prison. Another one, Gregory Parsons from Newfoundland and Labrador, was wrongfully convicted of murdering his mother in 1991. He was exonerated in 1998. The Newfoundland and Labrador government apologized and awarded him $650,000 in compensation. Another one, Thomas Soponow in Manitoba, was wrongfully convicted in 1981 for murder. He spent 4 years in jail. Judicial inquiry recommended an award of $2.6 million as compensation. The David Milgaard case in Saskatchewan received a lot of press. You may have heard of it. He spent 23 years in prison from the age of 16 when he was wrongfully convicted of murder. He was awarded $10 million. A case closer to home, at least for me here in Nova Scotia, was the Donald Marshall case. Wrongfully convicted of murder, spent 11 years in prison. After his legal fees were paid, he received less than $200,000 in compensation. So the Canadian court imposes a higher burden of proof in an attempt to reduce the number of people who go to jail falsely, wrongfully convicted. In conclusion of today's lessons, we're going to spend a few minutes discussing a reasonably well-known example of a serious incident where both civil and criminal actions were brought against hockey player Todd Bertuzzi. I provided a link to a CBC article in case you'd like to read more about it. You may have heard about it. I'll be honest, I hadn't. I'm not much of a hockey fan, but my students tell me that it is a pretty well-known case. So according to CBC, the notorious hit happened on March 8, 2004. Bertuzzi, then playing for the Vancouver Canucks, hit Moore from behind, sending the Colorado Avalanche rookie crashing face first into the ice. According to the article I've made reference to here, quote, Bertuzzi skated up behind him, tugging on his jersey, then punching him from behind and falling on top of him as other players piled on. Moore lay motionless on the ice in a pool of blood before being stretchered off and taken to hospital, end quote. Moore ended up having a concussion and fractured vertebrae. He never fully recovered from his injuries and was unable to continue his career. Bertuzzi pleaded guilty to criminal assault causing bodily harm for the hit, and he was sentenced in December 2004 to 1 year probation and 80 hours of community service. So it was therefore brought to a close in the criminal court, but a civil suit was filed by Moore. He said the lawsuit was not so much about the money as being compensated for the loss of his dreams. He said, and I quote, I lost my entire career in my rookie year. I think any player put in that situation would do the same thing. I can't recover anything else. I can't recover my career, the experience of living out my dream from the time I was 2.5 years old of playing in the NHL, end quote. So although the criminal case was brought to a close within the same year, 2004, the civil case actually took 10 years. It was brought to a close by a settlement agreement, and the details of that agreement are confidential. And so we look at this instance where something can be brought in terms of civil action through tort, as well as through criminal action. So in what ways do the criminal and civil actions against Bertuzzi overlap? And in which ways are they distinct? Well, the criminal and civil actions against Bertuzzi obviously overlap because the same course of conduct, his attack on Moore, gave rise to 2 legal consequences, one in tort pursuant to civil law and one under the criminal code. Differences arise, however, in what must be proven to establish the wrong in question, by whom and to what standard. So in terms of the criminal action, Bertuzzi pled guilty to a charge of assault causing bodily harm. But if he hadn't, the Crown would have had to prove beyond a reasonable doubt that Bertuzzi committed the crime as charged. So it would be up to the Crown, and it would have to be proven beyond a reasonable doubt. In a civil action based in tort, the plaintiff, so Moore, has to show that all the ingredients of the alleged tort actually occurred. So, for example, to establish the tort of battery, the injured party, Moore, must prove that Bertuzzi is responsible for the tort on the balance of probabilities. so the burden is less. As we're going to discuss when we get to Chapter 10, battery is the intentional infliction of harmful or offensive physical conduct. And we'll see more on this in future lessons. So that's it for Lesson 1A. If you have any questions at all, don't hesitate to get in touch. Bye for now.